Hello, Nigeria. Welcome to Plainsight Office Hours for May 1st, 2025. My name is Aaron Greenspan, and I just wanted to provide everyone with an update on the status of the Freedom of Information Act litigation involving Bola Tinubu, the president of Nigeria, in which I'm the plaintiff. As you may know, it's been a long slog. The first FOIA requests were filed nearly 3 years ago, in July 2022. Now, finally, we have a decision from Judge Howell of the United States District Court for the District of Columbia. My summary judgment motion has been granted in part and denied in part, but the granted in part is what really counts. The objections of the United States federal government have been found to be improperly alleged, which means that for the first time, documents about Bola Tinubu specifically will be released. Now, there has been a lot of misinformation about this case floating around in Nigerian media, so I want to make some things clear, because whenever you're dealing with federal courts in the United States, things can get very tricky and nuanced. So, first of all, this case really does not have much to do with Donald Trump at all. Donald Trump does not run the United States courts. The federal court system in the United States, which is established in Article 3 of the U.S. Constitution, is a separate and co-equal branch of government. And that's part of what has made America a place that so many people have wanted to come to for all these years, because it's a place where one part of the government, the executive branch, can face off against another, and they don't have to agree. And in fact, that is exactly what happened in this case. The FBI, DEA, IRS, CIA, State Department, and Executive Office for United States Attorneys are all part of the executive branch. And they went to court saying that these documents should be protected, and then another part of the government, the judicial branch, said, no, actually, you're wrong. So that's pretty remarkable. America is having a lot of problems right now, and I think it's fair to say that overall there's really no rule of law due to the Trump administration. But here and there, you do find these pockets where rule of law is still functioning, and that's really encouraging to see. Now, on to the second point I should clarify. Judge Howell's judicial opinion on the summary judgment motions was released on April 8th, 2025, and people might be wondering why I didn't have a lot to say about it. The reason is that the other side, in this case the government, always has the chance to appeal. So I didn't want to declare any sort of victory until I knew for sure that the government did not plan to appeal, because there might have been a chance that the ruling would be overturned, and it would be a long and arduous process that could take a year or maybe even 2. So it seemed like the safer thing to do was to wait. Now, I can tell you that the United States government has informed me that it does not plan to appeal, so Judge Howell's decision will stand. That is really excellent news. That brings me to the third point, which is to explain a bit of what Judge Howell's decision actually says and why this took so long. Earlier in the case, the different agencies all had to conduct searches for the files that I had requested, and once they found them at the FBI, DEA, and State Department, the court only required them to process a certain number of pages each month. Of those pages that were processed, some could be withheld. So just because, for example, the FBI processed 500 pages didn't mean that they actually had to turn over 500. I'd get maybe 200, and of those 200, there would be a lot of redactions, including every mention of Bola Tinubu. That's because the agencies were invoking a GLOMAR response, meaning that they would not confirm or deny that records existed. If you haven't already watched the Reality Check video series on the Plainsight channel about the Tinubu case, by the way, that series explains more about where GLOMAR comes from. In her decision, Judge Howell ruled that the agencies cannot invoke a GLOMAR response after all, and for the FBI and the DEA, she agreed with every argument I made about why that is. The 1993 civil forfeiture action against Bola Tinubu's bank accounts was filed by the United States Department of Justice, which is the parent agency of the FBI and the DEA, and also the Executive Office for United States Attorneys. When the US DOJ filed that case, they relied on the affidavit of IRS Special Agent Kevin Moss. But the IRS is not part of the US DOJ. It's part of the United States Department of the Treasury. So the government argued that because Kevin Moss wasn't an FBI or a DEA employee, his words didn't count. But there was a key point that the government knew but chose to ignore. When Assistant United States Attorney Marsha McClellan filed that case in 1993 against Tinubu's bank accounts, she didn't just throw that IRS affidavit on the desk and say, here, take a look at this. She wrote that she was incorporating the affidavit as part of the DOJ's complaint by reference. So, because the affidavit was incorporated by reference, Kevin Moss's words became Marsha McClellan's words. And since Marsha McClellan worked for the US DOJ, the parent agency of the FBI and the DEA, those agencies had to respect what their parent agency was telling them. So, it's a bit ironic that given Mr. Tinubu's age, the concept of respecting one's elders seems to have worked against him here. Judge Howell also disagreed that Bola Tinubu was entitled to personal privacy under FOIA exemptions B6 and B7C. That's because she ruled that when the DOJ revealed publicly in 1993 that Tinubu had been under investigation, his privacy interests became severely diminished. So severely diminished, in fact, that he really doesn't have any under U.S. law as far as FOIA is concerned. So that debate actually ended fairly quickly. You may remember that Bola Tinubu intervened in this case to have his lawyers file briefs as to why his privacy was important. Those legal briefs kind of missed the mark because they focused on his tax returns. But in order to accelerate the process of getting to summary judgment, I decided to strategically drop the IRS, the State Department, and the Executive Office for United States Attorneys from the case because it didn't seem like they actually had any documents anymore, or the documents they were providing just weren't that interesting. By the time we actually got to summary judgment, Tinubu's tax returns weren't even an issue, and they'd never been requested to begin with, just the criminal investigative files, which probably would have been shared with the FBI anyway. And finally, Judge Howell agreed that because Abiodun Agbele was mentioned in the disclosures, he couldn't be protected under privacy exemptions either. So, what now? You may have read that the documents are coming out tomorrow. Well, unfortunately, that's not quite true. Tomorrow, May 2nd, was Judge Howell's deadline for a status update, but we actually got that from the government officially today. Earlier in the week, I was informed that the government wanted 90 days to search for Tinubu's records. I suspect that they already did that search years ago, but they won't admit it if they did. In response, I said I wanted them to produce documents in 7 days, or at most 14, by separating out the files already identified. Unfortunately, Judge Howell didn't really address this at all. And sometimes that happens. Judges either ignore something they know they should pay attention to, or they're too busy, or who knows. But she set the next status update at 60 days from today, which means June 30th. The government is not required to turn anything over by then, just to tell Judge Howell what they've been up to for 60 days. So I've asked them to turn over the file sooner than that anyway. We'll see if I get a response. My guess is that by July, Bola Tinubu's FBI and DEA files will be made public, and I can't say exactly when, but this is all good news. When I started this process with David Hundeyen's help, I wasn't sure if it would go anywhere, but as it turns out, it really did. Thanks to David for providing the initial explanation as to what this case was really about, the filing fee, and a key email involving service of process early on. I hope this clears everything up, and if you have any questions, feel free to write in the comments, and thanks for your support.